I'm sorry, your bond recommendation, sir.
Thank you, Your Honor. I would ask the court consider a low 10% bond. I don't believe a PR bond is appropriate, so Mr. Nathan can get some jail credits while this case is while he has a hold, but low enough where he can hopefully soon be able to release. He's been working on Meridian Magnesium and eating wrappers for about 6 months, Your Honor. He's been paroled about 6 months ago. So to me, and I didn't ask him this, as soon as he got paroled is the soon enough when he got a job in Meridian Magnesium. He has no issues with his parole officer. He checks in constantly, good communication, tests. He has been working with no issues while on parole, Your Honor. This is a mere allegation. Mr. Jeremy presumes the right of is presumed innocent in this matter. I'd ask the court, given the fact that he is paroled, and he understands the consequences of violating parole, he's not going to be a flight risk. He is going to be appearing for court for every court hearing. Danger to the community, Your Honor, would be individualized in the allegation to one person, whoever that person may be, the complaining witness in this matter. Mr. Nathan is not an individual that's doing anything out of the ordinary. I believe a low 10% bond with a GPS tether would ensure return and any sort of concerns the court may have, keeping in mind that he has a parole agent. He's been on parole 6 months with no issues, Your Honor, besides this mere allegation.
All right, thank you. All right, Mr. Nathan, as I tell everybody, I'm going to look at two factors. Are you a flight risk? Are you a danger to the public? Looking at your criminal history, your ties to community, your employment status, glad to see that you're have stable employment. And we'll look at the allegations, recognizing absolutely that they are allegations. You have the presumption of innocence, and that's the way this system works, as it should be. I have reviewed your criminal history. You do have some felony convictions that date back to 2004. As I look for anything that is assaultive in nature, there is in 2004, which I agree is about 20 years ago. It's a felony home invasion first degree. In 2013, the next felony conviction you have is a felony criminal sexual conduct second degree. And in 2017, another felony complaint regarding narcotics. And in 2018, another felony conviction regarding a police officer assault resist obstruct charge. And in 2020, you further have a conviction of misdemeanor domestic violence, as well as a felony home invasion second degree. So you do have some considerable history of felony convictions and assaultive matters. As I look at this case, I do understand that the complaining witness was transported to the hospital for treatment, and I do have some serious concerns for her safety. In regards to bond, I also have a bond that I did share also with Mr. Anid through email earlier today. The people are requesting a $30,000 cash surety bond with a GPS tether to include 2,000 square foot exclusion zones and victim notification if possible to ensure the safety of the victim. Based on your history, sir, certainly you're on parole, so that does provide a semblance of supervision. Obviously, you know, things that happen here certainly can affect your parole. I'm not going to go as far as a 30,000, but I am going to follow a 10,000 cash surety to ensure, again, her safety as well as your appearance in court. The bond on that is, again, 10,000 cash surety with the following conditions. Do not miss any court dates, sir. Do not violate any state or local laws while you're on bond. Do not possess, purchase, or consume any alcohol or controlled substances without a prescription. And you are not to leave the state of Michigan without permission from the court. Additionally, you are not to possess or purchase any firearms, ammunition, or dangerous weapons, and you do have to report to pretrial services within 48 hours of your release. Also, sir, you are not to have any assaultive behavior or any contact at all with Ayanna Simmons. That means you cannot call her, you cannot write, page, email, text, no electronic communications of any kind. Can't have anybody else contact her on your behalf, and no threatening, harassing, or molesting behavior towards her or anyone else. And you cannot go within 2,000 feet of where she's located at any time. That includes her work, home, or school. So if you were to go into that 2,000-foot zone, Lansing Police Department would be notified, as well as the complaining witness, so that she can be sure that she's safe. No contact at all. If she calls you on the phone, you hang up. If you see her on the street in the grocery store, guess what? You turn around and go the other way. Absolutely no contact at all. Is there anything about that that you do not understand?
Understand.
All right. Anything else for the record, Mr. Unneed?
No, Your Honor, thank you.
All right. You're all set, sir. That concludes your arraignment. Doing a pretty decent job of writing on those bonds, aren't I?
Yeah.
Okay, Jesse Ray, please. Oh, here's Ms. CCH.
Hello, Your Honor.
All right, good afternoon, sir. Are you Jesse Ray? Is your middle name James?
Yes, it is, Your Honor.
All right, thank you. All right, and Mr. I need your appearance, please.
George Annette, APD on behalf of Jesse Ray for purposes of arraignment only today, Your Honor.
All right, thank you. All right, Mr. Ray, this is file number 25-02697FY. This is a motion affidavit and bench warrant, sir, on a stealing a financial transaction device from an offense date of March 1st of 2025. Sir, the bench warrant issued because you failed to appear for an arraignment on September 18th of this year. Can you tell me why you weren't in court that day, sir?
I actually moved out to Battle Creek and didn't change my address because I was living in my van. I didn't have a mailing address, so I never got the mail. I apologize for that, or I would have been there.
All right, so Mr. Ray, we're going to go ahead and get you arraigned. This is a complaint alleging in the people of the state of Michigan versus Jesse James Ray that you did on March 1st of 2025, knowingly retain, knowingly possess, knowingly secrete, or knowingly use a financial transaction device without the consent of Haley Ann Charrier, Charrier, the device holder. That is contrary to law. It is a felony, sir. Maximum penalty 4 years and or $5,000. Do you understand the charge and the maximum penalty, sir?
Yes, Your Honor.
Okay. Now, you also would have been provided an advice of rights today from the detention officer. Did you get that advice of rights?
Yes, I did, Your Honor.
All right. And were you able to read it?
Yes, Your Honor.
Good. And did you understand those rights?
I did, Your Honor.
All right. You also have the following rights. You have the right to remain silent. Anything you say or write can be used against you, and you always have the right to have a lawyer present with you at any time that you are questioned. Do you understand that, Mr. Ray?
Yes, I do, Your Honor.
Okay, good. Then, Mr. Arnett, is he applying for an attorney today?
Your Honor, I did not meet with Jesse Ray. I believe Joseph Hardy did. I do have the intake file, and the answer says yes. So I just want to confirm, Jesse Ray,
Oh,
you do
okay.
want us for arraignment today?
Yes, please.
Okay.
Okay, all right, good information, thank you. All right, so Mr. Ray, because this is a felony, you have two hearings. Your first hearing is a probable cause conference that is scheduled for Thursday, November 20th at 9:00 a.m. with Judge Ward. You do have to appear in person for both of these hearings. The second hearing, which is a preliminary exam, that is scheduled the following Wednesday, November 26th. That is at 9:00 a.m. Both hearings are with Judge Ward, so you should have the notice. Do you have it?
Yes, I do, Your Honor. I have it right
Okay,
here.
good. So hang on to that. Her courtroom is on the 6th floor of City Hall in courtroom 1. All right, now, is there anything I've told you you do not understand?
No, Your